All right. Good afternoon, everyone. It is officially afternoon now. Mr. Pinion, can you hear me?
Yes.
Mr. Bennett, can you hear me?
Yes, sir, I can.
Mr. Forte, can you hear the three of us?
Yes, Judge.
Great. Then I think we have everyone we need. Mr. Bennett, has your client, Mr. McNair, waived his presence for this bond hearing?
He has, Your Honor. I believe we filed a written waiver with the clerk of court either last week or the week before, but I'll ensure that that's in the record.
Okay, well, I trust that it is, but I'm gonna just look in Odyssey right now. So we've got belt and suspenders here. Let's see, 190322.
We were unable to e-file it due to the fact that the clerk is assigned a complaint room number.
Oh, right. But there's still something here. I don't know how you did it, but there on the 15th, a waiver of appearance for bond hearing was filed. So
Good old-fashioned hand service.
all right, way to go, hands. All right, so we're good to go then. This is 20 CP 190322, State versus Joshua McNair. Mr. McNair, through counsel, has filed a written waiver of his appearance. He's obviously in custody since we're talking about bond. He is not appearing remotely, but he is represented by counsel who is on this call. We've had a bond hearing in Mr. McNair's case before, so I'm going to let you, Mr. Bennett, refresh my recollection as to what the case is about, and then I assume we are here because time has passed and Mr. McNair's situation hasn't changed, which is not good news for him, but in some ways is somewhat unremarkable since we don't have a grand jury. I know that you did indicate in your motion that a handful of cases may have been indicted after your client was arrested, but I can assure you that there have been no indictments since mid-March because there have been no grand jurors. Before we go any further, someone just joined us. I need to know who that is.
It looks like our audio is also still in the process of connecting there.
Do you know who that is?
No, sir, I did provide the link
That is
to.
Dilma Dusres, victim advocate, unindicted homicides.
Okay, a colleague of yours, Ms. Rolak.
That is correct, Judge. Good afternoon.
Okay.
Good afternoon.
Good afternoon. Great. Mr. Bennett, we are live streaming this as well. So there is a link if your client has family members who want to follow what's going on, and the same is true for the victim's family members. We generally don't share the link to the Zoom call. We have had some folks try to be more active participants than they might have been were they just sitting in court. So we let them watch and listen to their heart's content.
Yes, sir.
All right, so Mr. Bennett, why don't you share with me where you think we are and what has changed such that I ought to reconsider my earlier ruling?
Sure, Judge. Just to refresh the court's recollection briefly, this is a case in which our client was charged with involuntary manslaughter, aggravated assault, and I believe one other count, possession of a firearm during the commission of a felony by the Roswell Police Department after an altercation with his former roommate who was in the process of being evicted. There are several witnesses that we expect would testify in our client's favor, both of whom were also roommates with the individual who was deceased. It's going to be likely, I think that this is probably going to be a case that goes to trial. I don't want to say that too early, but given the DA's position that they intend to upgrade the charges from manslaughter to potentially malice murder, I think that came out at the initial bond hearing. I think this is probably going to be a case that does go to trial. Now, for that reason, obviously, we're not having jury trials anywhere in the state of Georgia, probably anywhere in the country at this point, due to the pandemic. So we've already abrogated, at least temporarily, my client's constitutional right to a speedy and public trial by jury. My motion, I don't know whether the court has a copy of it. Obviously, statutorily, Mr. McNair is entitled to a bond. The judicial emergency order that was entered by Justice Melton on, I believe, March 13th states essentially that, all deadlines, time schedules, and filing requirements are hereby suspended by the judicial emergency order. So the argument that I'm making on a legal side of things, the change in circumstances is obviously we've passed the 90 days. So I would suggest that that's a change in circumstances. As for the judicial emergency order, my argument is pretty simple. The OCGA 17750 is not a deadline that's imposed on the state. It's not a filing requirement that's imposed on the state. Rather, it provides a benefit to a defendant who has been incarcerated for 90 plus days without a grand jury indictment. So it's sort of a positive right as opposed to a negative penalty to the state for not obtaining an indictment within the 90-day window. They could wait 4 years almost if they wanted to.
Right.
That's the statute. The only requirement that's placed upon them is the statute of limitations. That's essentially the substance of my argument in a nutshell, without actually, briefing it and providing a written submission to the court, which I'd be happy to do if the court feels that that's appropriate. I guess we can all agree that a presumptively innocent criminal defendant has a fundamental right to pretrial liberty. And that's because we don't impose punishment before someone's been convicted. And lengthy pretrial incarceration is, a form of punishment. It hampers the defendant's ability to, prepare his defense, to meet with his counsel. It leads to idleness and severe, ramifications for a person's personal life, for their professional career, for their income, for their families. It's a huge hindrance. And, I would suggest that since we've already taken away one fundamental right because of this pandemic, it would be unfair to Mr. McNair to also abrogate his right to a bond within a 90-day period of arrest. Now, that's the legal side of it. I don't know whether the court recalls, but when we had the initial bond hearing back, I believe it was March 18th, my client's father was present. His sister was present in court. And he expressed to the court that he runs a farm. He owns a pretty large property down in Dodge County, Georgia, Eastman area. And he intended to put Mr. McNair to work at the farm if he was released on bond. So what we would propose is pretrial supervision at the highest level, and that he be essentially confined to quarters within the dimensions of Mr. McNair's property, and be prohibited from leaving other than any potential medical issues, emergency situations. Ankle monitor conditions would certainly be appropriate for him. But I would suggest that keeping him 3 hours away from any witnesses involved in this case and confined to the dimensions of his father's property would be sufficient to ensure his compliance with court's orders, appearance in court, prevent him from influencing any witnesses, obviously strict no communication with any witnesses. We'd even be amenable to, you can't have a cell phone, you can't, internet access type stuff. So there can't be any manipulation on social media. Now, I don't anticipate that simply because all the witnesses to this incident seem to be on his side. And the Roswell police seem to agree with that, at least by virtue of the charges that they chose to bring. So that's what we'd ask for, Judge. Strict supervision, house arrest conditions, and confined to the farm. And I think that, the 90-day thing, that may be, it's a legal argument. I hadn't seen any authority for it other than, other people making the same argument. So I do think it makes sense to, if we're going to take away one right, we shouldn't take away all of them, because now we're getting into indefinite detention. There's no end in sight for this, and we don't know when jury trials are coming back, Judge.
Willie McNair is who, Mr. Bennett?
That's my client's father. I actually gave him the Zoom link before I knew I wasn't supposed to do that. I apologize for that.
That's all right. If he stays off video and stays mute, he can plug in that way.
Okay, I'll make it clear that that's what's expected. Yes, sir.
Okay. Mr. Pinion, I don't think you were here. I think maybe it was Mr. Abate who argued this for the state. this was maybe one of the last things we did before we reduced people's appearances in court. But regardless of when we did it, my recollection is Mr. Abate handled this for the state. You can correct me, but either way, you now have the baton for the state, and I'd like to hear your perspective on this.
Okay, thank you, Your Honor. It was Mr. Abate that handled it. And I read back through what Your Honor had asked to have a summary of some of the witnesses' testimony. And that what you just said, that Mr. Abate indicated that the state would be upgrading the charges. I do concur with that. Just reading the warrant, it seems the officer was trying to he wrote out the terminology for voluntary manslaughter. I don't know if he knew the difference between voluntary and involuntary, but he put it as a sudden provocation. I would just note, contrary to what the defense counsel just said, that all the witnesses are on the defendant's side, there were 4 people out there and one is on his side, the person that called him his best friend. But the deceased, Mr. Bay's brother, was also out there, and he is certainly not on the defendant's side, and has said that this was just basically a murder. And I believe everybody agrees that the victim was unarmed. I've listened to all of the witness statements, and I found nothing to the contrary there. Your Honor, I don't believe there's been any change in circumstances. I think that the 90 days is told under the judicial emergency. The case will be indicted. I see it as soon as we can have a grand jury. And as to the defendant, I don't believe he has ties to any certain address. After watching his statement, I realized that he was also asked to leave and move out of the place where the incident arose, at the 148 Grove Way Apartments. So I don't know that he has a history at his dad's address. So I don't see his dad here. I don't know anything about that address, but he has an unstable living arrangements, and we believe there's no change of circumstances. The case is ready for indictment, and that we believe bond should be denied. I do have a statement from the brother that I could read at this time, Your Honor. He is working and had asked that I be able to read this at the appropriate time.
Okay, I'll hear from you in just a second. I have a couple questions. I need to know who is calling in from phone number 478-559-0963.
That's his father,
Whose father?
Joshua Elias McNair.
All right, I'm going to mute you, sir. Please don't unmute. All right, Mr. Pinion, before you share with me the statement from the deceased brother, I hear you that your review of the information doesn't show that Mr. McNair has a connection with his father's property, but I don't think that's what Mr. Bennett ever represented. My understanding was that Mr. McNair had been in the Atlanta area, had been living in this apartment for a while. Maybe he also was moving out. To me, that may be instrumental into the dynamic between the deceased and Mr. McNair, but the set of conditions that Mr. Bennett has identified is more compelling than we usually hear. It's not, I'll go back living where I was before with my mom looking after me, who was looking after me before when I was running around in the streets and I shot someone. It would be move 3 hours away, have an ankle, basically, instead of house arrest, it's farm arrest, but you would stay in this property in Dublin. And the only time with an ankle monitor with GPS paid for by the defendant or defendant's family. And the only reason you would leave the property would be because there's a medical issue or because you're coming up here to court, or whatever we agree to fashion the limitations. Tell me why that doesn't address the Ayala factors here, in your opinion.
Yes, I do agree that that helps alleviate some of the concerns on the Ayala factors. I did not know anything about the father and that farm out of the Atlanta area until we got on the call here. After watching the defendant's video, that was never mentioned. He mentioned his mother in the past and that his mother had passed away, and then he'd only been in this apartment a short period of time. So I was concerned about him having a stable address.
Sure. When you say the defendant's video, he gave a statement to law enforcement?
Yes.
Okay.
Yes. And yeah, he was mentioning that the owner of the premises was asking all the parties to leave.
Okay.
So that was a concern to me that has somewhat been alleviated. It is good to hear that his father is on this call as well.
I think he was in court when Mr. Abate was here. I'm pretty sure I've met Mr. McNair in at a distance in person. He was here on behalf of his son when we did the first bond hearing. But if you have concerns you want to articulate as to why effectively a house arrest am I right in saying Dublin? That's what you said, Mr. Bennett?
Yes, sir. I believe Dodge County, which is Eastman, but Dublin may also be in Dodge County. It's sort of out in the country between the two towns.
Dodge County, house arrest, farm arrest down in Dodge County. Tell me what concerns you would have other than the usual. Well, he could cut off his ankle monitor and go to Mexico, which I'm not minimizing. You've made it clear, and I'm sure Mr. Bennett will in turn make it clear to his client, but you've made it clear, Mr. Pinion, that involuntary manslaughter is not where this case will stay. I having looked at some of the paperwork in the case, scratched my head a little bit as to how those were the charges. But of course, it's a CP case. Those aren't necessarily the charges that the district attorney's office would bring. So the plot thickens for Mr. McNair. But I want your responses to I'll call it the bond package that Mr. Bennett has proposed. I agree with you, and I've only scratched the surface, Mr. Pinion, but I agree with you that the Chief Justice's order has told the 90 days. We can't bring matters before a grand jury. DA's office can't, and so I believe that if a legal challenge were brought to the Court of Appeals, which is where this case would go, given the current charges, the finding would be that even that time frame has been told. It becomes more complicated if and when the Chief Justice says, if you want to have grand jurors now, you can, if it's safe for your jurisdiction, because then it's the chief judge who steps in to decide whether for a specific circuit it's safe, but we're not even there yet. So I don't think that clock has started ticking again. Doesn't preclude Mr. Bennett from pursuing that further if I end up not setting a bond, but Mr. Pinion, you don't need to push that one anymore.
Your Honor, I don't have a pretrial services report on him. Do we know a pretrial? I looked on Odyssey and I did not see that there was one. I have tried to get a copy of any past criminal record. I have not been able to get one. It is not showing anything in Odyssey. There is actually one other case, but looking at the photo, it is not the defendant. It's a different Joshua McNair. So I haven't heard argued that he doesn't have any previous arrests. That may be the case.
So I'll share with you what's in the pretrial report. It is in Odyssey. If you go to the documents tab for this CP case, and it may be, I don't know what access ADAs have, but I can see it.
Okay.
They did not recommend release because of no verifiable community ties. The recommendation narrative explained that Mr. McNair's last arrest was in November of 2017 for a probation violation out of Marietta. But he does not appear to have an open case pending, and he does not appear, that's how it's worded, to be on probation or parole, and does not have felony convictions within the past 10 years. He has reported residing in the metro Atlanta area for 27 years. He's a forklift operator, admits to some drug usage. He does appear to be a flight risk because of his unverifiable ties to the community. They were not able to verify his address or ties to the community because defendant could not provide any references. So the concerns flagged by pretrial services were not criminal history, open active cases, but we're not sure that Mr. McNair would make himself available for trial. So
Okay.
that was their concern. Mr. Bennett has responded to that by saying he'd be on the farm in Dodge County.
Yes, and so that's consistent with what my looking at the case was. And he did mention, the defendant mentioned in his video, working, but it was through a temporary staffing agency. So the lack of a verifiable address at that time, I was concerned with the serious nature of the charge, that we were looking at upgrading it, that he would be a flight risk, and that if Your Honor is inclined to give a bond, I know the victim's family wishes that there not be a bond granted in this. If you are inclined, given the lack of a stable address in the past, we would ask that it be a high bond that appear, and that certainly an ankle monitor and basically house arrest, if it is a farm, that be implicated by the judge.
Okay.
In the
Why don't
order.
you share with me, Mr. Pinion or Ms. Rolak or Ms. Dos Reyes, what the deceased's family wanted to share. I'm of course interested in hearing that.
I can read it. I already spoke to the others and said that I would, and it just said, this is Bilal Bey, the deceased brother. On behalf of the family, I don't believe Joshua McNair should be let out. March 2nd, the defendant came looking for my brother and said he couldn't stay there anymore. And Mr. McNair had a gun. When my brother got home, he realized that his lockbox was missing. And I walked outside, this is the brother speaking in the first person, and saw them arguing. McNair's friend ran up and also jumped on my brother. When I texted to help his friend yelled, "Get the gun," and Mr. McNair started shooting. He shot my brother in front of me. He shot up my car. He shot up my girlfriend's car. It was scary and sad. And ever since then, I believe that he is too dangerous, and he knows our address and where we live. And my little brother is now on depression medication, and we're having flashbacks. So his concern is, this happened right outside of the living brother's apartment, and he still lives there. So he's concerned the defendant knows where he lives, and the psychological effects that this had on him are understandable.
Sure. Okay. Well, I appreciate you sharing that. Ms. Dos Reyes, was there anything else from the victim's family?
No, Judge, just that. Thank you.
You're welcome. Thank you.
Thank you, Judge.
All right, Mr. Bennett, anything you want to say in closing?
Just lastly, Judge, the version of the facts that's provided by Mr. Bilal Ray will be in dispute. As for the witnesses, I certainly agree that Mr. Ray is a witness. However, there were also two witnesses that are going, in my belief, going to tend to corroborate Mr. McNair's version of what happened, that it was an eviction, that he was attacked, and that he defended himself. But of course, those are issues to be sorted out at trial. They don't affect the Ayala factors directly.
Right.
But,
No, I understand that. It's helpful to understand a little bit of the dynamic, but your point's well taken. So, Mr. Bennett, one thing you didn't share is what you think the right bond amount is if I'm going to set a bond. I could say $100 million, but that's really not a bond because I suspect that's too high. That might reflect my concern about Mr. McNair's lack of ties to the community. But I understand Mr. Pinion thinks no bond is the right answer. And if it's going to be a bond, it ought to be high. But I don't recall you talking about a dollar amount. And I'm interested to know if whatever dollar amount I set can be secured in part by the real estate that Mr. McNair's father owns, so that Mr. McNair knows there'll be consequences to people beyond himself should he decide not to handle release in a mature way.
Yes, sir. And I'm not extremely familiar with the financial resources of this family. I know there is real property that could potentially secure the bond or the bail bond. But I was going to ask for $50,000 property or surety, but that was just going to be a starting point. Of course, if it's permitted to be secured by property instead of putting a dollar amount, that I'm sure we could probably make that happen.
Okay. Do you have any sense of the amount of equity that the McNair family has in the land in Dodge County?
No, sir, we have not discussed that.
Okay. All right. Well, why don't you find out from Mr. McNair Sr. What that is, and I will take this under advisement and get a bond order out in the next day or so that either reaffirms the denial. The basis that I gave for the denial last time was a concern that Mr. McNair posed a threat or danger to the community or people in light of how, after I asked for additional bits of the discovery that Mr. Abate supplied to me as well as you, Mr. Bennett, it seemed like this was a little more than an involuntary manslaughter case. So that's the starting point. Things have changed and that more time has passed. I think we all have a better sense that a grand jury's reappearance in Fulton County is a more remote thing than hey, I know it's going to be August 15th. So we're going to let it get indicted, see what those charges are, because it will undoubtedly be some charges for which he has not yet been arrested. So there'd be no bond on those new charges, and we just repeat the cycle. And that's kind of inefficient to get him out on bond only to have him have to turn himself in 3 weeks later. But we're not talking about 3 weeks. I know from good sources that we will not have grand jurors here in the next 3 weeks. So if you can get that information, Mr. Bennett, to Mr. Pinion and to Ms. Nelson, that information being the amount of equity the family has in the property in Dodge County. And then of course, their willingness to have that equity secure part of the bond. This is not really interesting if the answer is 200,000, but they're not confident that Joshua McNair would be a viable candidate for house arrest. But if you share that, that will give me a better sense of what kind of anchor we'd have. And then I will let you all know what I'm going to do.
And
Understood.
Your Honor, I did just get just in the last minute, his GCIC. If I could just give you that information, it is not, it's not overwhelmingly bad, given what we're used to.
I assume there are no felonies because he was not arrested for felon in possession of a firearm, which usually
That's
moves us
correct.
a whole nother category.
Yes, that's correct. There was a 2012 NOLO to false information. It looks like a false name to a police officer. That was a NOLO plea. Then 2016, again, another NOLO plea to false name and date of birth to an officer. And then 2017, I did find that one now. That was a marijuana charge, misdemeanor, and that was again a NOLO. And then there was some kind of violation of that probation. Actually, the violation of probation was for a driving offense, which looks like may have been it doesn't state what kind of driving offense it was, but there was it doesn't look like he completed his community service for that.
Okay. Well, I would
And
agree with you that that's not as serious as what we sometimes see.
no, yeah. So he did this was his 7th arrest. He did another probation violation, but it wasn't anything violent.
Okay.
So.
Got it. Well, he went
All right.
from 0 to 60 very quickly, at least in terms of allegations. We'll see how it plays out. All right, so Mr. Bennett, we'll look for that information after you have a chance to speak with Mr. McNair's father. And then I will get something filed and that will get to you all and we'll take it from there. And
Yes,
there
sir.
may be
Thank
some follow-up. It could be that when I get the information, I don't want to, if I intend to have it be a bond that is within reach, then it may have to go through an iteration or two. So I guess the other piece of information you could share after you've conferred with the family is what is a combination of equity in the property plus money they could put up. I'll tell you, and this is not a mandate, but I'm a big fan of the sheriff's 10% program. They pay a little more up front, but they get almost all of it back, as opposed to lining the pockets of the bonding company, which
Right.
is never going to find Mr. McNair if he disappears anyway. And I don't know that we have forfeited a bond in the last 20 years here in Fulton County. So it's a win-win situation for bonding companies, but it's usually a little less than 10%. It's just that the folks who put the money up never see it again. So if you'd have that conversation as to what they could support through equity as well as partly a good bond, either through the sheriff's 10% program or through a bonding company.
Yes, sir. I will do that. I'll get back to you guys before the end of the day. Yes, Your Honor.
All right, sounds good. Anything else, Mr. Pinion?
No, Your Honor. Thank you.
All right, thanks, everyone.
Thank you.
Judge, on the next bond hearing with Mr. Wright, he had suddenly a conflict. He asked to hold for his report.
Okay, but it's the same call. We don't have to start a different Zoom session.
Correct. I think, yes, all the calls will be on the same Zoom.
Oh, fantastic. And I think, Mr. Pinion, this will be your case as well.
Ooh,
No,
which
I
case
think
is
that's Ms. Hall's case, Judge.
Oh, okay. I'm sorry. I thought it was, it's not a murder case. All right.
All right. Whoops.
Oh, right. This is the case where the guy, like, he got hit by a van or something, but he was just coincidentally there. I remember this case. All right, I have to sign off for a minute, but I'll be back on in a little bit.
Okay.
There's someone here for that? Okay. Let me see. I'm having trouble with email, unfortunately. But I think I have that. Let's open that. Yep, she's position 6. So she's welcome to stay outside, or it's big enough she can be in here, whatever you guys prefer. Okay. Her attorney will either be zooming in or will be walking in. She's got a public defender. When Ms. Day is here, I think she'll end up, when her lawyer is here, just sitting with her lawyer. I don't think she'll need to say anything at the podium. But we'll see. I think so. I never know until we get started. It's a public defender. Sometimes they're physically here. I know one of the 2 of them is going to be here today. I don't know if they both are. So we just go with the flow. So Ms. Nelson, I'm going to make you the host again. And because I have to restart this, and then I will graciously accept being host back when I get back on, okay? Hey, Ms. Nelson, I was gone for a little bit. Mr. Wright doesn't have a whole lot more time to plug in with us before we need to shift to status. We've got some defendants actually showing up here in court. So, Ms. Nelson, can you hear me?
Yes, sorry, Judge, I was working on a calendar problem.
Okay. Any update from Mr. Wright?
No. Let me reach out to them to see what's going on. But he had said hold for his report, so it made me think he might be a minute. Let me
Okay.
check with him.
I mean, it's fine. If he shows up 2 minutes before 2, we're not going to do his hearing. We're going to do the status calendar because we have inmates physically here, not inmates. We have defendants physically here. So as soon as we start getting some of our other lawyers to dial in, I think we'll start with the status stuff.
Okay, I'll let his assistant know that.
Thank you. Hey there. Is it easy to get in the building or do they make it?
They have the prior street side closed off schedule all the way around.
Do you normally try to get in through the Prior Street side? Okay, I'll bring that. We learned about that secondhand and the courts were not consulted with, but it was
And then I tried to go in, the second door.
the Carnes building.
Yeah, and my badge didn't make me an employee. And they wouldn't let me in that side.
Okay, we'll work on that. I think that's supposed to be, is that right? The Carnes building entrance is employees?
There was a sign that said employees only, and when I showed them my badge, they said that I wasn't a Fulton County employee.
What does your badge say?
GPC.
Okay, it doesn't look like the rest of them, but that's info we can share with Colonel Moffett and his team so that they know conflict defenders ought to be permitted in. Okay. We'll follow it from two angles, but I think that's the solution so that people can still, employees can still get in from this side. Sorry about that. Hello, Ms. Hall. Good afternoon. Do you have any trouble getting in the building?
I did, but I wasn't sure if I used the right entrance or not. This is the 136.
So the normal Prior Street one, they're not operating anymore. Were you able to get in through Carnes?
I was.
Okay.
Your badge says Fulton County, doesn't it?
Oh, yeah. She's real.
But see, even Fulton County was A, my badge still said GPC.
Well, you can probably get into more buildings with that than just here, but this is the one that matters.
See, today was my first day trying 136 and it's locked. And I was like, wait. I thought it's closed.
Yeah, they didn't push that info out a whole lot.
Yeah. Cause you have to like walk out to the door and like look at it to see the like the.
Yeah.
entrance is closed sign. Yeah, I thought we were like, this is the employee entrance, and I went all over the steps, it was locked on me too, so I was like, okay, cool. So yes, I went through, and it's space, that space for it, yeah, I tried to go through that way, and they wouldn't let me through my badge in Fulton County. Oh. Never had that problem with it. Yeah, I can't get it, I think there's something going, so maybe it's more. Just afternoon, school. That's why they didn't.
GPDSC, that's what it says.
Yeah, Georgia Public Defender Council.
Is there an S in there or no S?
Not anymore.
GPDC.
Like 2 years, 2 years ago.
Okay.
It's just GPDC. It says state of Georgia Metro Conflict Defender.
Hey there. I'm not sure what you're asking.
You want the whole laptop set up?
Yeah, the usual thing. Yes, please. Oh, before you go, let me find out. I don't think we're doing the evidentiary hearing. I think your client's showing up, which is wise. But because of the late provided discovery, have the officers, hopefully you all have been communicating. I get the email secondhand, but the officers shouldn't show up if Mr. Franklin just got video that he ought to review in order to meaningfully examine them. The reason why I'm asking is that they need to bring in another laptop if we're going to have someone at the witness stand. But it doesn't sound like we're going to have an evidentiary hearing today. Is that correct?
Right, I talked to the officer, they both were there, right? So, the other officer.
But if he shows up, he's not testifying today.
That's,
Right.
that was the request.
Okay. And I'm okay, given the way that played out. It's not optimal, but so we need one laptop, not there. We did originally, but this just in, the hearing's not going forward. So, but we certainly need that one set up.
Hi, Judge. How are you? This is Nakia Sellers.
Hey, Ms. Sellers, how are you?
I'm doing well. I was trying to reach out to Ms. Snyder and to Ms. Patel.
Okay, Ms. Snyder is sitting here in court.
Okay.
So you'll be able to see and hear her in a little bit. We're setting up the equipment that will allow folks in the courtroom to be seen and heard. That's happening right now. Ms. Patel will either be here virtually or in person any minute now. She's a couple minutes late.
Maybe I can reach Ms. Snyder on her cell phone. I just wanted to touch base with her.
Sure.
Possible.
Let me connect you two in just a second. Mr. Taylor, we haven't forgotten you. I see you sitting there. You're good. You can stay mute. You're the first position on the calendar. We're just getting all the equipment set up, okay? Great. Is there a number you'd like me to text to Ms.
Sure.
Sellers to give you a call? Or
I can put my number in the chat.
yeah, or I can give you her number. Why don't you just write yours down and I'll text it to her. So it's not going across YouTube. Thank you.
Thank you, Judge.
You're welcome. All right, so I should go in a little bit. I'll go mute here. It'll just be like old times in theory. Okay, I'm gonna go send something to the printer and I'll come back.
The meeting not in the chat for it wasn't in the, they can put it in my ticket
The password to make that work?
for the Zoom meeting ID.
Oh, the Zoom meeting and ID, sure. We need to put that in the ticket. You've asked for that kind of stuff before. Hold on, let me open it up. All right, you ready?
Yes.
ID 835-6979-8360. Password 966-816.
Thank you.
You bet. All right, I gotta go print something out. So Ms. Hall,
This one?
Ms. Hall,
Yes, sir.
we may still do the O'Neill bond hearing.
here and talk.
Mr. Wright is tied up in Clayton County. We would do it after this county.
That's fine.
If he's not ready by the time we finish this, I'm not gonna make him sit around. This is the case where the guy's leg is broken real badly, coincidentally jumping out of the van, like
Yeah.
right at the crime scene. We'll hear it at some point.
Okay.
What are we looking at? What are we looking at? There's an interesting debate in the bond hearing today as to whether 17,750, it says you have to have a bond set after 90 days if we haven't been indicted. That was told by the Chief Justice's various orders. This defense attorney was saying it was not, you can't stop that clock. I bet you would. I don't think the court would agree with you. You should keep arguing. You don't have to worry about CP bonds. Yeah.
Not for now.
Not for now.
I hear things.
Yeah. Hey, if it's a CP case related to one of our cases, we should try to work them together.
There's a lot of
Well, you guys, we're all set up? Okay, let's see if we have everyone we need and we'll check the audio. Ms. Patel, would you mind, just because you are sitting closest, going up to the podium so we can check the audio there? All right, Mr. Forte, can you hear me?
Yes, Judge, you were clearer earlier today. I don't know if it's because we're going through the courtroom microphones or what, but you're not as clear as you were earlier today.
How about now? I just turned my microphone on. Does that make it better?
That does make it better.
Okay, good. Ms. Patel, would you see if we can test the microphone up there?
How are you doing today, Mr. Forte?
Doing well, thank you. That sounds great.
All right. Ms., I think the microphones are supposed to work at the tables as well. Would you say hello and share your greetings with Mr. Forte?
I'm Mr. Forte. How are you?
Doing great, Ms. Hall. Thank you. You sound great.
Thank you.
Ms. Snyder, would you try out the microphone there and wish Mr. Forte the best?
This one is off. The red button is on.
Should it be on or off? On. Let's make it green.
Can you hear me, Mr. Forte?
Yes, but you'll need to get a little closer, please.
How about now?
That's better.
Great. Okay. Ms. Sellers, just to test things, you are on the call. Were you able to hear all the different people who were talking? She may have stepped away. How about Ms.
No,
Rowe?
I'm here, Your Honor. Yes, I heard everyone. I was trying to unmute myself. Yes, I heard everything.
Classic YouTube video, people trying to unmute. All right, great, thank you. I think we're ready to go then. This is our status calendar. Thank you, gentlemen. Do we check with you when it's over? Is that the best thing for you all? If I just shoot an email saying we're done?
Yep.
Okay, which one of you, or just to court support? Thank you. All right, we have a status calendar with 9 positions. Some folks are here in person, which is great. Some are online, which is also great. Our first position is Cedric Taylor. Mr. Taylor has been on the call for a while now. Mr. Franklin, is that your case?
No, Your Honor.
Is it? Ms. Snyder?
Was a conflict of interest.
Great, all right.
Before me.
All right, so let me just see what the entry, wow, this is a case from 2015 and we found you, Mr. Taylor, that's good. So this was on a status calendar in late April. You were terminated from Veterans Court. This is why we have Ms. Sellers on the call. Ms. Sellers, are we dealing with the results of the termination, or did Judge Newkirk already handle the results of the termination?
Oh, Your Honor, we are dealing with the results of the termination, and this was actually under Judge Markle.
Okay.
When he was the Veterans Court judge. Mr. Taylor was terminated for going AWOL from the program, and we are today.
Okay,
So
it's a track 2, which
it is
a dying breed. We got rid of track 2 in our new referral form because it was the bane of many people's existence. So I'm pulling up Mr. Taylor's case now. Done a good job of keeping us posted on his address when he resurfaced. So here's the termination order from January of 2017.
Yeah.
And now here we are 3.5 years later. So why don't you start and let me know, Ms. Sellers, what you think ought to happen, and then I'll hear from Ms. Snyder, and then if we need to do a formal proceeding, we can get things on the record. Although, my understanding of how track 2 works is that effectively Mr. Taylor entered a plea, but if he had successfully completed Veterans Court, which he did not, then the charges would somehow be dismissed even though he pled. But because he pled and he got terminated, he's pled, and so maybe all we're doing is talking about sentencing. But my confusion is one of the reasons why track 2 became disfavored.
So, Your Honor, as I understand, I've looked through Odyssey and combed through, I did not see a disposition for Mr. Taylor, nor did I see where there was a recommended sentence that was held in abeyance. I didn't see that information. So at this point, we are looking to just move forward with a plea, Your Honor.
It looks like, though it's labeled as a track 2, it really is functionally a track 1. I'm looking at it as well. And there was a trial notice and then a referral, order of admission. The order of admission says track 2, but apparently it was Judge Downs. It was not a track 2. And Mr. Taylor, I'm not trying to speak in strange code around you. We're just trying to figure out what the posture of your case is, whether these charges, it looks like it's a burglary allegation, are something you already pled guilty to, or if you have not. And it looks like you did not enter a plea. You went to Veterans Court. Unfortunately, that didn't work out. And so we're at a crossroads now where either you can take your case to trial or you can resolve it another way. I'm gonna have your lawyer talk for a little bit and then we'll see what we're gonna do, okay?
Okay.
Right.
One second, could I say something, please, Judge?
Sure.
Just to clarify, it wasn't a, I guess, traditional me quitting the program or anything. If the paperwork shows it, or I may have to talk to my ex, but I quit the program because at the time, me and my girlfriend had a miscarriage, and I was at the hospital the following day, and I called my officer, my case manager, and I told him what happened, and he still wanted me to come in to, and he arrested me. You know, I didn't have any time to, you know, grieve or anything like that. And I talked to Judge Markle, and he understood where I was coming from. And he told me to go ahead and, if I wanted to, go ahead and leave the program so I could deal with that.
Okay, but it may have been what we call a soft termination. But either way, and you'll have a chance, and Ms. Snyder will have a chance to put more color behind the situation so we know more about it. You were terminated, and you have this burglary charge, and we need to figure out what we're going to do with it. So let me hear from Ms. Snyder a little bit, and then we'll figure out what we're going to do. Does that work for you, Mr. Taylor?
Yes, sir.
Great. Ms. Snyder?
Judge, this was previously on our status calendar in April. It was reset for today for notice because it's so old. I didn't have any contact information for Mr. Taylor. And there's not really anything on Odyssey that shows what the sentence should have been. So that's part of what we're doing. So Ms. Sellers is going to get me the discovery so I can at least have a look at what he's accused of, and then we can have an intelligent conversation about whether this is going to be a resentencing or where we go from here.
Okay. It doesn't sound like it will be a resentencing. You're going to, of course, take a look at that discovery, and now you know how to connect with Mr. Taylor, so you guys will talk. But it sounds like the crossroads will be at after you and Mr. Taylor talk, after you've had a chance to look at discovery. Is there a non-trial disposition, or is this a case that you and Mr. Taylor think should go to trial? You're not in a position to advise him on that yet, because it is an old indictment, and who knows what discovery is out there. But Ms. Sellers will get it to you. It involves an incident from November 2015, a house in Sandy Springs, or an apartment in Sandy Springs. So how much time would you like before we put this back on an inquiry calendar to figure out what we're going to do with the case?
I guess that depends on how long it takes Ms. Sellers admin to get me the discovery, because I know everything's moving just a little bit slowly with people only coming to the office every now and again.
Okay. Ms. Sellers, how much time would you like to be able to find the discovery in this case and get it to Ms. Snyder?
I think a reasonable reset is a month, Your Honor.
Well, is that how much time you'd like to get her the discovery, or you think between now and August 21st or thereabout, you would be able to get the discovery and Ms. Snyder would have a chance to? I can't imagine there's a whole lot of discovery. It's a one-count burglary case, but you still need to get it and get it to Ms. Snyder. And so I'm wondering how much time you'd like to, what kind of deadline you'd like for that?
Well, I will go ahead and put that request in today to my legal assistant to get that information. I haven't done a whole lot of discovery during this time, just because as a accountability court prosecutor, I just normally don't do that. But I would suspect it would take at least, to be fair, 2 weeks.
Okay. Hold on one second. I didn't realize I was not on video. There I am. All right. So if we put this on an inquiry calendar in either late August or early September, that's going to give you a few weeks to digest discovery, connect with Mr. Taylor. Do you have his contact information?
Yeah, I was going to ask if you could get a phone number from him on the private chat.
Sure, we'll do that. Mr. Taylor, are you, let me ask you if you can see, hold on one second. I'm sending you a chat text. Let me know if you get this.
Okay. Yes, sir.
All right, if you would put your phone number in there, I will share that with Ms. Snyder so that she has a way of reaching you, because she's going to want to talk with you about your case and your intentions. And then when she gets discovery, she'll want to talk with you about that as well. And I got it. Great, an email address as well. You're very thorough. I'll share that 8 email addresses. Okay. Are you from Chicago?
Yes, sir.
Okay. He's from Chicago. I'll forward this to Ms. Snyder and she'll reach out to you. And what we'll do, Ms. Sellers, is put this case on an inquiry calendar in late August or early September. That ought to build in enough time for you to do what you need to do, get the info to Ms. Snyder, and she's off and running. Okay?
Thank you, Your Honor.
Do you have anything else, Ms. Snyder, for Mr. Taylor?
No, Your Honor, I would just ask for the September versus August date because we've been told by Judge Cox we're gonna have a lot of court in August. So just know that I might need a little bit more time.
We'll do it. It'll be early September. It'll be a fun month of August. All right. So Ms. Nelson, if you could have this case next appear on an inquiry calendar in early September, maybe we'll be able to resolve it then. Thank you. All right. Thanks, Mr. Taylor. You're good to go.
All right, thank you. Have a good one.
You too. Just writing down his stuff. Okay, Ms. Sellers, do you have another case or is that it?
Mr. Edwin Edwards.
Oh, that happens to be the next case. Is Edwin Edwards here? He's here. Hey, Mr. Edwards. I'm doing okay. You can stay right there for a minute. We'll figure out what's going to happen with your case. It may be that you need to come up to the podium. Just wanted to make sure that you're here. Who's handling the case for Mr. Edwards?
That'd be me, Your Honor. I had pre-tried this case with Ms. Hall, and we had potentially worked out a plea. So I think that maybe the 3 of us need to chat to see if that's something that Ms. Sellers is amenable to.
Okay, Ms. Sellers, I don't know how much of that you could hear. You want me to repeat what was said?
Yes, it was a little limited, but what I could hear.
Sure. So Ms. Patel didn't realize that you were handling this case.
Okay.
It sounds like maybe Ms. Hall didn't either. So your colleague, Ms. Hall, and Ms. Patel, on behalf of Mr. Edwards, negotiated a resolution, but they don't want to exclude you from the fund. And so they wanted to figure out a way to confer with you because there may well be a way that we can still resolve this case. We got Mr. Edwards here today, and if we could, that'd be great.
Okay.
So maybe when we get to, we take a quick pause and Ms. Hall, do you know how to reach Ms. Sellers?
I do. Actually, Your Honor, me and Ms. Sellers have talked about this case and she, I couldn't give Ms. Patel what she was asking for, but Ms. Sellers came up with a better, resolution. So maybe they just need to talk about that and see if we can still have a resolution.
Wow, okay. Well, don't think you can always go to Ms. Sellers to get a better deal. All right. So Ms. Patel and Ms. Sellers will talk when we get to a case that doesn't involve the 2 of you. And we'll keep Mr. Edwards here because we may be able to sort things out on this 16 SC case. Do you know how to reach Ms. Sellers?
I believe I have her cell phone number. If it hasn't changed anytime soon, I have it in my phone.
Okay.
I'll
Has your
text
cell
you.
phone number changed?
No, it has not.
Okay, great. Then Ms. Patel will give you a call when she gets a break here. So please stick around.
Thank you, Your Honor.
You're welcome. So Jerry Peck is next. Is Mr. Peck here? He's got 2 cases. I don't see him dialing in.
He should be still in custody.
Right.
In custody. That would, okay, given these charges, that's possible. There's Ms. Hodge. Hello, Ms. Hodge.
Good afternoon, Your Honor. How are you?
I'm okay. Your case, Mr. Franklin?
No, Mr. Gregory entered on the CWAC case.
Mr. Gregory is a private attorney?
Yes, sir.
Okay. He's listed as attorney for both cases.
I don't recall him ever entering on the battery. I thought that I still had the battery, but perhaps he did enter on that one.
I don't know.
There was an issue in December. Mr. Peck was to go to trial on the CWAC charge. Mr. Peck did not show the trial. And from what I understand, Mr. Gregory showed late that day. And he also showed,
remembering this.
He showed up late and he showed up with a request to withdraw.
Oh.
So I think that may have been on the calendar that that still needs to be addressed.
Okay. Yeah, and there's a note here listed under the family violence battery position, but attorney the 13th of December filed a motion to withdraw, no order entered. I don't see Attorney Gregory here.
It takes a happen.
Okay. Ms. Nelson, have you had any successful communication with Attorney Gregory?
I had back in, I guess it must have been December, our last calendar, the status, and that's when I was informed that he had put in for a motion to withdraw. I talked to his assistant and let her know that it hadn't been approved. I sent this calendar to the assistant, letting them know about this conference, but I have not gotten any response.
Okay, so the notion was today we would speak with Attorney Gregory about are you in or are you out?
Correct.
And if he's out, then we have to, so he was retained at some point by Mr. Peck.
He was retained and withdrew on the day that he was supposed to pick a jury.
That didn't work out. And Mr. Peck didn't show up for the jury.
Correct.
I'm going to reach out to the assistant now and see if I can get a response.
Okay, and that generated a bench warrant and now Mr. Peck's in custody?
That and Mr. Peck picked up another CWAC charge. Wow.
Yes,
Oh, I think I remember Ms. Hodge telling me about this. It's unindicted.
Correct.
correct.
So Mr. Peck
It's-
is gonna
It's
stay where-
20 CP 189060, Your Honor.
Right. While on bond, picked up another one. Okay. So I'll work out what's happening with representation and Mr. Peck. He was your case,
4 times.
so it will go back to you if, or was there a conflict that you had? Or he simply said, I want to pay for it?
He just hired an attorney.
Okay, so if Mr. Gregory is relieved of responsibility for whichever case or cases he's on, then it all flows back to you?
If he is relieved, yes, sir.
Okay, all right. Do you have a position on whether he should be relieved?
I feel that if you walk in on the morning of trial and you try to withdraw that day, that should factor in.
Okay, well, I need to meet Mr. Gregory and we'll work through that. All right, so Ms. Nelson is reaching out to him. If you don't mind sticking on the line a little bit longer, Ms. Hodge, because Mr. Gregory could dial in and we could at least get his input. I'm not gonna require him to come on down here. He needs to connect one way or the other. So we'll see what Ms. Nelson is able to figure out. Because I don't think you have anything else on this calendar. So I'm gonna give Mr. Gregory 15 minutes to figure out if he's gonna dial in or not, and we'll handle it in a different way after that.
Okay, Your Honor, I'll hold.
Thanks. September 8th is going to be the inquiry calendar, Ms. Snyder, for, you'll get it many weeks in advance, but for planning purposes, to be 8 days past your hard month labor. All right, position 5 is Antarius McGuire.
I don't believe Mr. McGuire is here, but he was also waiting for an evaluation to be performed, ex parte. We have reached out several times to the persons who should get the evaluation done. I CC'd Ms. Nelson last week on an email. We received a response back from a woman by the name of Ms. Pack, and she informed us that somebody else would try to get in touch with Mr. McGuire today. I'm not sure if they've made contact though.
So Ms. Pack is not associated with Mr. McGuire, she's associated with the folks who'd be doing the eval?
Yes, sir.
Okay, so they've just taken him, so he's out on bond?
He's on bond. This was the case right when the COVID epidemic stuff kind of started. We attempted to take a plea that day, and I went to the back and said, I don't think we could do it.
Yeah.
And we got a bond instead.
Okay.
So I've been in touch with his sister, just like, hey, have they called you all yet? And,
So he is in a stable location, it's not an issue of we can't find Mr.
correct.
McGuire?
I've maintained contact with his sister. I haven't attempted to speak with him. I just want to make sure the status of the eval.
Right, okay, so he got bond in early April and made bond at early May and hasn't been evaluated. Okay, but you are bugging the people who were supposed to do it.
Yes, sir.
So is it somehow you're finding that evaluations are occurring more quickly for folks who are in custody?
I can't say that perhaps it is, but I don't have anyone off the top of my head who I know that I've submitted an evaluation on who's still in custody, and I know that they've been evaluated.
I know some of those have gone through. We had Ms. Brown and a few others where they have been able to do it. I'm not suggesting we need to change his status.
No, I got you.
Complying with bond, he is. We just need to figure out what the breakdown is.
Yeah. I know for a while there was a period where they weren't going to the jail. I don't think that's the case any longer. I think they are going to the jail and getting things done as best as they can. I'm not sure what the holdup is with the persons who are on custody, out of custody.
Is Mr. McGuire expected to go to the evaluator or the other way around?
If I were to, because I haven't heard what the plan is, typically what happens is they would possibly contact Your Honor on a regularly scheduled court date. We find a room. I think the jury room would be big enough.
Okay.
So
we would provide the space.
That's how we would do it for persons on custody pre-COVID. I'm not sure if they would be willing to do it by phone or by Zoom or something at this point, but pre-COVID, we would have them come in from.
Okay, I thought they don't go to like 55 Park Place. Okay. So you reached out, they told you they're looking into it. We don't want to forget about Mr. McGuire. How far out should we put an inquiry calendar?
A couple of weeks should be fine, at least for me to have a response back as to whether or not they've tried to make contact and they haven't been able to, or yes, we have and we have a date. Because again, they were supposed to get back to me yesterday.
Was Mr. McGuire supposed to be here today, or we all agreed he didn't need to be here?
I didn't inform him to show up because I knew that the eval wasn't done. There was nothing substantive to be accomplished.
Okay.
I knew this would be my announcement, but I also assumed it was a status, and perhaps just look at the title.
It says status. How about discovery?
We have some initial discovery, and I saw that something else was emailed to me today by Ms. Hall's assistant. I'm not sure what that is, but it's a domestic allegation. It's not something that requires any super unique investigation.
Didn't sound, I mean, it sounds like you're gonna have.
Again, we almost had a resolution at plea arraignment, so
Okay.
I don't foresee that being an issue.
You don't think it's stalled out on discovery, you think it's stalled out on evaluation?
Correct.
When you decide that a client, in your opinion, ought to be evaluated, do you typically then stop communicating directly with him or her? Because you mentioned you'll reach out to Mr. McGuire's sister, but not Mr. McGuire.
I reached out to his sister because it was her phone. That was the number I had, and I'm not sure that he had a steady number himself.
Okay.
And because my inquiry was, hey, has this event occurred?
Right.
Yeah.
She can answer that as well as you. Okay, all right. And Mr. McGuire is staying away from Ms. Barber while on bond, I take it.
I have no indication otherwise.
Okay, all right. Then we'll put it on an inquiry. It may be a little more than 2 weeks out, just because Ms. Nelson generally gets those calendars published further in advance. But in the near term, we'll put on an inquiry calendar. I guess I'm going to ask then, if the answer is still nothing's happened, that with your permission, you let me get involved to say, what do we need to do?
If you care to get involved now, I know that Ms. Nelson she's on the email chain where I inquired about it. I don't have any objection if you want to throw your weight around and just ask, hey, when can this get
It's
done?
not about throwing my weight around, it's just asking nicely. I'll let you do the weight throwing, and we'll see what happens at the next calendar, and then I'll get involved.
Yes, sir.
All right. Ms. Patel, have you been chatting with Ms. Sellers? Or
She has
texting?
my number, but I'm going to text her discussing this offer.
Okay, so you're communicating?
Yes, we
Okay,
are
great.
communicating.
Keep communicating. Inquiry to, all right, that's Mr. McGuire. Ms. Day, I know Ms. Day is here. There's Ms. Day. So you're gonna need to pause, Ms. Patel, unless you want me to jump to well, you're standing up. So
Oh,
that's fine.
it'll be fast. Regarding Miss Day, Your Honor, we just need some more time. We're trying to get her into Mary Hall Freedom House. And then as soon as she gets accepted, we would like to use that in our negotiations with the state because we are heavily pre-trying this.
So this is a trafficking allegation, not just a simple possession.
Correct. But there are mitigating circumstances in terms of who had ownership of this item.
Okay. Is there a co-defendant or Ms. Day is the only defendant?
She's the only defendant, but
Only
there
one
was
defendant.
another person in the car
Okay.
with her.
And because of the nature of the charges, drug court's not an option, or why Mary Hall Freedom House as opposed to drug court?
So, Miss Day was revoked on parole and then she was released. And so Mary Hall, in terms of providing the immediate necessities of stable housing, basically getting her in there as soon as possible, was our approach.
Okay. This was last on a calendar almost 3 months ago. So we've been trying to get into Mary Hall Freedom House for 3 months, or tell me what's happened since April 28th.
No, Your Honor, I did not have communication with Miss Day because of her being sent to DOC and then being released. But fortunately, she was able to reach out to me and we communicated, and then I got her in touch with my social worker, and they've been working to try to get her into Mary Hall.
Okay, got it. I think if you, I'm just looking at the docket from a prompt I got from Ms. Nelson. I don't know that Ms. Day has been arraigned before my time on the case, but if you would fill out a waiver of arraignment form, that would be a good next step in this case. How is discovery going? That's not a hang up right now?
No, I was served body camera footage, which I think would have been the only thing, as well as drug lots. I think that that's the only thing that the state would have had in this case.
Okay. All right. So we're good with discovery. Your team, Ms. Patel, is working hard to get Ms. Day into Mary Hall Freedom House, which is a great place if you can get there. How long has Ms. Day been on your radar, meaning back in Atlanta, not in custody, but not in Mary Hall Freedom House? Just ballpark, I mean, is it a week? Is it?
No, I would say maybe a month and a half, 2 months that we had been working on that. But it took a while for my social worker to reach out to Ms. Day and set up the interview. But hopefully, I think she interviewed.
I talked to her on Thursday. And
Okay.
I called yesterday and spoke to the young lady. I had to get like different tests done, and then I had to go up there and do my application.
Where are you staying in the meantime? I don't mean street address, but with whom are you
My
staying?
mom,
Pardon?
my mother's house.
Your mother?
Yes.
Okay. But your hope is to get into that structured environment at
Yes.
Mary Hall? Okay.
But in the meantime, I've been working in at home.
What kind of work?
I do inventory, I'm an auditor.
Where?
I count product, I work for PICS.
What's that?
It's like an inventory specialist company. We go to like different companies like Publix, Lowe's, and do the inventory.
Okay,
Yes, sir.
got it. All right. So if you would do the waiver of arraignment, it looks like a supplemental discovery was provided in late May. So you hopefully got everything. I don't know that we'll do a full-blown scheduling order. We'll certainly set a motions deadline if there are going to be motions, but it sounds like, Ms. Patel, you're trying to create a framework for a non-trial resolution with Mary Hall Freedom House being sort of the backbone of that. But until Ms. Day gets in there, you can't offer that up to the state as a possible solution. So I want to make sure the case continues to move along. Ms. Day is at risk if she's not getting that type of treatment. I guess the next stop for this would be a motions hearing date, if there are going to be motions, and then a final plea date. Obviously, if you sort something out before then, we should get Ms. Day in here and take care of that. Ms. Hall, anything you want to add in connection with Ms. Day's case?
No, Your Honor, I'm still doing my part, even with what Ms. Patel is doing to try to resolve the case.
Okay, good. Then we'll get a scheduling order issued once the waiver of arraignment is filed, and we'll take it from there. All right, thank you, Ms. Day. Don't go until Ms. Patel says you can go. She may want to talk to you.
Thank you.
You bet. Christopher Bryant.
Yes, sir.
Is that you again, Ms. Patel?
Yes, Your Honor.
All right. Mr. Bryant has two cases, a theft and cocaine case, and then a burglary case. Let me just read the notes here. Bond in early April. We're supposed to check on discovery. Looks like we need more waiver of arraignments. These are some of these cases where that kind of thing didn't happen in late 2019, and we just want to make sure it's all buttoned up. So does waiver of arraignment include entry of appearance? If you do that, will that, because there's no lawyer listed for Mr. Bryant in his higher numbered indictment.
It does include the entry of appearance, Your Honor.
Great. How is discovery going in the two cases?
I spoke with Ms. Hall about what is outstanding, and I also need to get Ms. Hall some information on my end that I'm hoping, now that I can meet with my client today, that we might be able to try to do. And so the goal is towards a resolution, not trial, but I know that Ms. Hall can't do much on the burglary until I show her what I have. And then Ms. Hall knows that she needs to get there's a video of this burglary that, and a video of an individual at a pawn shop that needs to be turned over.
Okay. So what's a aggressive time frame that we can use? Because these are cases from last year. I know it's complicated to track things down, but I'm just pulling up the lower number indictment. So it's an accusation, but it's almost a year old now. It will be on August 16th. Got his bond. And he lost his bond. Okay, so it sort of was frozen for a while because we had no Mr. Bryant, but now we do.
Right.
It's not going anywhere. Right?
Yes, sir.
Okay. There really hasn't been much since he got the bond. So keep working on discovery. If you'll enter the waiver of arraignment in both cases, we'll get a scheduling order out that will set a motions deadline, but it doesn't sound like this is one where you want to go in that direction. You want to go in the direction of working the case out.
Correct.
Okay. Ms. Hall, anything you want to discuss about Mr. Bryant's two cases?
No, Your Honor, I've ordered discovery, just waiting for it to return.
So this was an accusation from August of 2019, well before your time. I get that. But why would discovery be ordered only now?
Well, I ordered it before today's date, but there was no supplemental discovery in the actual file. It doesn't mean that it wasn't ordered before me or provided, but because I have no proof, I just reordered and reissued.
Got it. So this certificate of discovery from November of last year from Ms. Iqbal, that's just the basics.
Right.
It's the police report, and you can sit down. You don't have to keep standing. Sorry about that. So that's, even though it's a whole bunch of pages, it's not going to have anything supplemental to your point. And then I guess because folks lost track of Mr. Bryant, well, there was a supplemental discovery on the 30th of December. So I was kind of fun where body cam footage was provided. Do you have the body cam footage, Ms. Patel? Hopefully the state doesn't have to provide that again. This is in the case ending in 559. It's a flash drive that was provided. Felt like a new, it has your name as counsel of record. It's a New Year's Eve.
Yes,
Okay.
I was given this on the original
Good.
FTA.
All right. So we look like we're pretty good with discovery there. Okay. So when you say you're requesting again, I'm just trying to understand the process. Some poor person at whatever police agency is involved may be getting you the body cam footage all over again.
Because again, even though Ms. Patel has it, unless she makes a copy for me, I don't have it. So if it's not in the actual file and like it wasn't given to me by the previous attorney, I have no way of looking at anything. So then I reorder it and I tell them I apologize if it's any inconvenience, but I have no way of knowing. Other than, you know, seeing that it was filed, and even if it is filed, if it's not in the file, I don't have it. So then I don't know what's going on.
So in this case, Ms. Iqbal got body cam footage, gave it to the defense, but effectively didn't give it to you. She might
Right,
have a drawer.
or the legal assistant, because sometimes we give it to them and then they.
I'm not blaming a specific person, I'm just sort of hoping
Right,
the
right, right.
process.
She gave me a very large pile of supplemental discovery and I filed them in all the files that I had, but I ran out and anything that I don't see now, I just reorder it.
Okay.
Instead of losing it or not being able to have it.
And
Okay.
the other issue just to add was that we were being given the supplemental discovery before a client was present. So in this case, we're given the supplemental discovery when the client was in FTA status and we didn't even have an active file on the case. And so I imagine that those things probably got lost in the process given that
Okay.
the individual wasn't present.
We'll just do it again. We'll get scheduling orders out on Mr. Bryant's 2 cases and see what we can do. Anything else we need to talk about with Mr. Bryant, Ms. Patel?
No, Your Honor.
Would you like him to stay?
Yes, Your Honor.
All right, sit tight, Mr. Bryant. And last but not least, Johnny Hardiman. There he is.
Mr. Franklin.
Okay, he'll be right back in. Wow, you're on bond. Let me look at this case up.
You'll probably remember it, Your Honor.
I'm sure I'll remember it in a minute. Someone started telling me about it. I'm just looking at the charges.
I'm not a sports player today.
You talking about Mr. Hardiman?
Yeah, he's here. And I looked at the charges and I was surprised. So tell me,
We got
Ms.
some,
Hall said while you were out of the courtroom, you'll remember this case. Remind me, why am I going to remember this case?
the allegations are that there's a gentleman who was at a party or something to that effect. He initially told one story that is
Mr.
definitely
Dixon?
yes,
Victim?
yeah. He told a story that's an absolute falsehood. He told a story that he was going to his car, he dropped a phone or a wallet, and then he went back out of his car with the keys already in the ignition, and somebody else hopped in and took his car. That's how the cops come to the scene. When the cops get to the scene, he says, actually, by the way, it's this person who I know by whatever nickname, who turns out to be Mr. Hardiman. My initial conversations, based on my conversations with Mr. Hardiman, my initial investigation rather, we seem to have a pretty good alibi. If I recall correctly, this was either New Year's Eve or somebody's birthday. There was a date that that person has a reason to remember. And I spoke with the person who said that who Mr. Hardeman said that he was with. The person confirmed that information for me. We argued that.
Yeah, it's New Year's Day. It's January 1 of this year when these things allegedly happened. I'm remembering now, and I see the bond that Mr. Hardeman got, $45,000 bond. How are things going on bond? Good. All right. So let's talk shop. Want to make sure you did the waiver of arraignment, so we're good there. How's discovery going?
Discovery is going.
It doesn't sound like there could be a lot of discovery in this case based on how it played out.
Ms. Hall gave me a link to the evidence.com link of a body cam video I need to review. And I didn't mention this to Ms. Hall when we spoke the other day. I think there was a lineup that was done.
There was.
And I need the actual lineup, but those are the only things that I've just received or know that I still need to receive.
Okay. The body cam footage you've got now, make sure you download it before the link expires. Doesn't sound like that, unless your client gave a statement that would yield any motions. But the lineup might yield a motion because they often do. Remind me, did you acknowledge that your client and Mr. Dixon knew each other, so it's not stranger on stranger? Oh, you said he had this nickname. Yeah, I think it was so-and-so. Initially, just jumped in my car, but then later on, it was no at gunpoint.
Correct. And again, I'm not sure what the level of truth is to this. During the initial discovery packet, what was said was that Mr. Dixon said that he met Mr. Hardeman at the party, whether he knew him from before or not, or is telling other lies.
Okay.
We don't know.
And you're saying that you believe the evidence will end up showing that Mr. Hardeman wasn't at this party and wasn't near this car because it's a memorable day, and on New Year's Day, or effectively New Year's Eve morning, he was with so-and-so somewhere else.
Yes, sir.
Okay. And that's the kind of information you're sharing with Ms. Hall?
It's stuff I need to follow up on.
Okay.
To be honest, I thought Mr. Hardeman was still in custody. I went away that he had made bond.
Oh,
so
there he is.
Yeah. Until he walked in this morning, I said, I know that face, but
Okay.
we hadn't met in person before because COVID.
When did you get out? June the 19th. Okay. So it took like 2-3 weeks to make the bond. All right. So we need to get a scheduling order entered. Any reason why it shouldn't just sort of be the standard time? I know because you got the body cam video, you're waiting on the photo lineup, but that seems fairly gettable. It's not like a in-store video where we struggle somewhere.
I don't see any reason why the standard turnover date for the state, that kind of thing doesn't.
Let me make sure, I meant to do this with the other gentleman. Yeah. Mr. Hardman, oh, now I'm confused by that. The address we've got in the system has you on Guinness Road.
Yes, sir.
That's a good address?
Yes, sir, 3628.
Yeah, apartment.
Yes, sir.
Okay, all right, good. Because that's how we get in touch with you. I mean, hopefully, Mr. Franklin's gonna get a phone number from you so he can hit you anytime. But when you're getting notices from us, they'll go to that address. If you move, that's gotta be okay with pretrial because you've got pretrial supervision. But if you move, you gotta make sure you provide that new address so it goes in the system. Because it's up to you to keep us posted, okay? All right. So we'll get a scheduling order entered for Mr. Hardeman now that the waiver of arraignment has been filed, and that will guide the case forward. Ms. Nelson, there's a W next to Mr. Hardeman's name. Is there something we need to work through?
Let me check, Judge.
Okay. Don't go anywhere.
Still checking.
Problem. All right, it's good. It was a electronic warrant for something that he's dealt with. So, you guys need to talk.
We like to say,
You guys know. All right, Mr. Hardiman, it's good seeing you. Make sure you stick with the conditions of your bond, and you'll get notice in the mail to that address we talked about for the next time you need to come to court. But if you ever have any questions, reach out to Mr. Franklin, okay? All right, take care. So, do we have an update on Mr. Edwards, or is that still working?
Your Honor, it's still being worked out. Ms. Sellers is going to speak to Ms. McCauley. If we can't resolve it today, though, we will reset it to another date for plea, but I think that we're trying to potentially move forward today.
Great.
The only issue is that, so we were trying to globally resolve all 3 cases. I don't think that this should come in the way of us entering a plea today, if that's the case, but he's never formally been terminated on the other 2 cases.
I can fix that.
Right. And we're taking a plea into the program anyway.
Back into BHTC?
Yes, yes,
And BHTC knows this?
yes, yes.
Who says that, Mr.
Mr. Tucker.
Mr. Tucker?
Yes.
All right. So it would just be a track 4, well, we don't call that, it would be a probationary referral.
Right,
Okay.
correct.
So not track 3, but probationary referral. And it would be a condition in all 3 cases.
Right, well, potentially just 2 cases.
Okay, however it's.
Right, so, right, we're trying to figure that out.
Okay, well, while I'm remembering, let me confirm. Mr. Edwards, I have several different addresses for you. One of them is Holly Parkway in Fairburn.
That's the one I'm at now.
That's a good address?
Yes, sir.
Okay, not Stone Road.
No, sir.
Is that an old address?
Yes.
Okay, so the one we should use is the Holly Parkway.
Yes, 939.
9039? Okay. And who lives there besides you? My mom. Okay. Well, I'm good to go with time, so let's see if we can sort it out. If Ms. McCauley can be reached in her special tower where she sits. We got dispensation. And we'll pick it up if we can. There's still some folks here. So if Ms. Snyder, are you done? Oh, sorry, it's on this little, I don't have big posters up here. You have a phone number and 2 email addresses, but make sure you can read all that before you leave. I have the handwriting. You got it? Okay. So that is Mr. Taylor. Mr. Edwards is still here. Mr. Peck is, so hopefully Ms. Hodge, you can go. I appreciate you staying on. Mr. Gregory's team told Ms. Nelson that at about 10 minutes to 2, he's got a 2 o'clock Zoom. So he declined, even though he'd only need to be on with us for about 2 minutes to say, I don't want to be involved with the case anymore. So I'm going to deal with Mr. Gregory. And I will let you and Mr. Franklin know how that plays out.
Okay,
And
Thank
and
you,
Ms.
Your
Hall. Ms. Hall always does. Thanks for joining us.
okay, thank you.
The battery case is mine still. I tried to give it away.
I did send another email that said that exact same thing. He had 2 minutes, he had 10 minutes, he could still join the conference.
Yeah. No, I trust you gave him all the opportunity to do the right thing. So Ms. Day is still here because you want to talk with Ms. Day.
Yes.
All right, great. Do we want to, oh, let me see. Did Mr. LeBlanc show up?
All right.
He's right there. All right.
Who did you say show, Judge?
Pardon me?
Who did you say appeared?
Did I pronounce it correctly? LeBlanc? Yeah, Mr.
Oh.
LeBlanc, the gentleman who has the motions calendar.
Okay, thank you.
Do you all want to talk about that now?
Yes.
Okay. Yes, ma'am. Thanks for being here. And I have drug court tomorrow, so that won't be any of you all. And I think that's it for the rest of the week. All right, you can get ready for August. mind checking with either Ms. Patel or Mr. Franklin?
See what's going on.
Yeah. If they are making progress on sorting the case out, that's great. I don't know what happened with Mr. LeBlanc, that we could take care of that.
Yeah, Ms. Patel said she's still working on it.
Okay, Mr. Edwards.
Yes.
Okay. How about Mr. LeBlanc?
We're not closer on like an agreement. We will have to, Ms. Hall has had a chance to review the video. And what he told me, I still think I'm most likely viable. So I just released it from wrong.
Okay.
I thought that we were having most of it.
I just wanted to know, it's often helpful to have them in here, while we talk about what's next. So next time, that's okay, just next time, wait till we're done. He's here, he was here, that was the important part. I did want to confirm his address, but you've got a good phone number for him. What are we doing next? So you haven't seen the video yet, or you?
I haven't.
Okay, so you'll watch it, but you think, having heard what's in the video, it does not undermine your motion. I read your motion. They respond to some kids are hanging out, the guys are hanging out. Stop, they grab them, and we'll hear what the officers have to say. I think I understand the nature of the constitutional concern. So we need to have that hearing. It sounds like the officers were willing to come.
Yes.
So it wasn't that, it was that they, despite you having asked a bunch of times, they said, oh, and here's this other evidence.
Well, when it wasn't even the officers, it was actually open records. They said it didn't exist at all. And that's because they're transferring systems because of COVID. Excuse me. I'm not sick. It was just me talking. Because of COVID. And so they don't have the ability to know what's not there. They just tell us it doesn't exist. But talking to the officer, they're like, no, I watched it with my own eyes. And I watched it again today. So it was a fight with that. And I mean, that's a lot of cases now coming from College Park.
Okay, so College Park has some issues.
Yeah.
You guys will work through that. We just need to set this down again far enough out to get notice to the officers who are night patrol. So it's gonna be tricky for them anyway. Is morning better than afternoon for them? Or morning is bedtime and so they'd like to do afternoon?
I think afternoon would be better because one officer told me that he would get about 5 hours of sleep and then come in for the motion.
Okay.
So I think the
So
afternoon is
we'll
better.
set it for sort of the same time, 2-ish or something.
Yes.
We'll send notice to Mr. LeBlanc, I'm assuming the address in the system is the right address.
And he called me today, so he received notice.
Okay, he called you,
He called my office number, he called my cell, I had to call the older number.
okay. All right, so he said, hey, I got this notice, what should I do?
Correct.
Okay.
Call him.
All right. In terms of discovery, anything else, or you think now you've got 99% of it, and more importantly, enough to make the hearing meaningful?
Definitely.
Okay.
And the only thing else that I'm not clear if it was provided, I provided Mr. Franklin maybe 10 or so audio recordings, and it's all the conversations between the officers from dispatch on dispatch forward. However, I don't know if that includes the 911 call. So we're still waiting on that. That was an issue as well when we went to pick up this evidence. So if it is anything else, it's the actual 911 call.
Okay,
I did
but the
give him-
911 call is going to be the convenience store owner or whoever it was saying, there's some guys loitering out here.
Right, well, it's more specific. They're saying that they're watching them sell drugs. And
Okay.
So it's,
Okay,
so we kind of need it. I just don't know if it's included. I listened to the majority of those calls. I got the CAD report, but I don't remember the actual 911 call. So I will
Okay.
check into that today.
all right. Well, I'll get with Ms. Nelson, and if we set this back on in a couple of weeks, that's not too soon.
Not for me. I told the officers that the
I
problem.
have listened to the dispatch audio stuff already. I didn't hear.
You didn't hear the 911? Oh. I don't think you did, because I feel like I listened to everything and I don't remember that. But I'll call them. Like I said, they're having system issues, but that's something we were waiting on. But when I got the dump yesterday, I thought that was everything.
Okay, well, they wouldn't have heard the 911 call anyway.
No.
So
It
we
would've
could,
just been a
you
dispatch.
could ask the officers all the questions you want. If you need to supplement the record with the 911 call, you can do that, but that's not anything the officers would do.
Right.
Okay. All right. So we'll get a new date for that. I think that's it for LeBlanc. Okay. So then we'll wait to see what we do with Mr. Edwards' case, and I think that takes care of our calendars for today.
Your Honor, we do have a resolution.
Okay. Will Ms. Hall be handling it, or will Ms. Sellers? do it?
I believe Ms. Sellers, she's still on the call.
She is, yeah.
I'm here.
Great, okay, well, let's, do you need to talk to Mr. Edwards before we get going, Ms. Costello?
Your Honor, I just need to have them sign the referral.
Okay,
Your Honor, would you like for me to wait around for Mr.
Mr. Ray.
O'Neill's case?
nah,
Okay.
we'll reschedule that.
I'll probably head home. If he comes or appears, I can always hop on Zoom. I say,
Yeah, I mean, I allocated time for it, and that time has passed, so.
oh, okay,
We will, have it happen another time.
okay. Ma'am, you.
Yes, ma'am, thank
Thank
you.
you.
I'll see you next week. Mr. Forte, you got rid of the fish, and we have some mosaic. Are you ready to do some takedown?
Ready, Judge?
You'll say that the police, I will be here to try to make the visit. And you're gonna have the referrals whenever I can search.
Okay. Tell me what we're doing. Mr. Edwards has 3 cases, and we're taking pleas to 2 of them, or to 3, or?
To your honor, the case ending in 615 is being null crossed.
Okay. So we're going forward with a plea on the matter that's on the calendar, that ends in 425, and we'll take a plea in the 921 matter, 615 is being null crossed.
Yes, your honor.
Okay. You agree with that, Ms. Sellers?
Yes, Your Honor, 5 years to serve 1, that 1-year community time served.
Okay. But my question was, one of the 3 cases is being dismissed, is being null crossed.
Yes, yes, Your Honor.
Great. All right, I think I understand what we're doing. Ms. Nelson will email me the 2 indictments so we can deal with that. Let me get situated here. And Ms. Nelson, Mr. Edwards's good address is the party correspondence one, not the one where we've been sending things. That
He needs to do it. He needs to.
Correspondence is what I would think is where Odyssey sends it. Got this little
No,
pin next to it, but that's not the good address. That's where you lived at one point, the Stone Road, but the Holly Parkway is the good address.
he needs to do a new.
No,
he needs
Your honor,
to-
we had a bond modification. He is
See, that-
living at a new address.
Yeah, they don't change it again to the 384, my baby mama house, my children's mother,
Okay, so you're not at Holly Parkway
it's-
or Stone Road.
384 Simpson Terry.
He needs to
Okay.
do an address change form, please, Judge.
Yep, we'll take care of that. Ms. Patel is gonna fill out another form. It's over there, on that counter, it's an address change form.
All right.
So that we get it in there. So you were at one point at Holly Parkway, at another point Stone Road,
Yes.
but now it's this 384 Simpson.
Terrace, yes.
Okay, we'll get that filled out.
All
All right, so before we go on the record, Mr. Edwards, my understanding is that you're gonna enter a plea to 2 cases. They're both old. One's from 2016, where you're charged with obstruction of an officer, and one is from 2014, and I'll have to look at the indictment and see what you're charged with. But you're gonna enter pleas to both of those. Sounds like you're getting a sentence that is effectively probation, and the main condition of your probation is that you will go back to BHTC, Behavioral Health Treatment Court,
Yes, sir.
and successfully complete that. Is that your understanding?
Yes, sir.
Okay, great. Well, we'll have more to talk about. Let me make sure we are good to go with everything here. Yep, I see all the folks we need. So Mr. Edwards, in just a moment, Ms. Sellers is going to swear you in. So she can have you raise your right hand,
Okay.
swear to tell the truth, etc. Once you're under oath, it's important that you answer all of her questions, and Ms. Sellers will have most of the questions, but I'm going to have some too. Answer both our questions truthfully and completely.
Yes,
So
sir.
if at any point you cannot understand what we're talking about because you cannot hear Ms. Sellers, or we're just saying something that doesn't make sense, or it's different from what you thought was going to happen, will you let Ms. Patel or me know that?
Yes, sir.
Great. And then we'll do our best to explain what's going on. And if at any point you just want to take a time out to talk with Ms. Patel, let me know, and we'll make that happen. Okay?
Yes, sir.
Great. When you're ready, Ms. Sellers.
Thank you, Your Honor. Would you please raise your right hand? Do you swear or affirm that the statements that you will provide to the court today will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may place your hand down. Would you please state your true and correct name for court's record?
Edwin Edwards.
Okay. And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
11th grade.
How old are you?
30.
And you are able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are being charged with the following offenses in 16 SC 142425? You're being charged with felony obstruction of a law enforcement officer, and that carries a sentence of 1 to 5 years. And in 14 SC 124921, you're being charged with the sale of cocaine and the possession with intent to distribute cocaine, and that carries a sentence of 5 to 30 years. Do you understand that?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
And counsel, have you all filled out a waiver of rights form?
No.
Okay, okay.
Normally, we would do that, but not today. You familiar? Just want to make sure you know what she's talking about.
The plea sheet, yes.
Yeah, okay.
Okay. And have you had enough time to speak with your attorney, Ms. Patel, about all of the facts and circumstances known to you regarding the charges in these two cases?
Yes, ma'am.
And do you need any more time to discuss this case with your attorney?
No, ma'am.
And are you satisfied with your attorney's services today?
Yes, ma'am.
Okay. Counsel, do you waive formal reading of the indictments?
We waive.
Okay. Do you waive any and all defects in the indictment?
Waive for the purposes of this plea only.
Do you understand that this is a negotiated plea of guilty, which means that the state has recommended that the state, represented by myself, and I have spoken with your attorney, and we have a joint recommendation to the court. That recommendation is 5 years to serve 1 year, and that 1 year is commuted to time served. And a special condition of probation is to successfully complete the behavioral health treatment court program. And so do you understand that recommendation to the court?
Yes, ma'am.
And do you understand that the court does not have to follow that recommendation, and that the court has the entire range of the sentence to sentence you to today?
Yes, ma'am.
And do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
And do you understand that if you are currently on probation, you may be revoked based on you entering a guilty plea today?
Yes, ma'am.
And do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
You understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
You understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you. That's not an issue right now because we're looking at probation, but the court may see otherwise. So you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial.
Yes, ma'am.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison.
Yes, ma'am. I understand.
Understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today.
Yes, ma'am.
And do you understand that if you went to trial, you have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
You understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial. Do you understand these rights you're giving up today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
And it is your decision to waive these rights and enter a guilty plea because you are, in fact, guilty.
Yes, ma'am.
How do you plead to the charges in 14 SC 124921, sale of cocaine?
Oh, guilty.
And how do you plead to the charges in 16 SC 142425, obstruction of a law enforcement officer?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes, ma'am.
Okay. At this time, the state will go on the record with the facts in this case. Okay. If this case This is for 14 SC 124921. And if this case would have gone to trial, the state would prove the following facts beyond a reasonable doubt: that on February 20th, 2014, at 654 Boulevard Northeast in Atlanta, Georgia, in Fulton County, Georgia, at approximately 9 p.m., Officer Lyle observed defendant Henley, Miss Henley, purchase a piece of crack cocaine from defendant Edwards and he saw the exchange of U.S. currency. Miss Henley was arrested as she walked away and admitted she had crack cocaine in her pocket, which she turned over to the police. And then Miss Henley advised the police that she had just purchased the drugs from defendant Edwards. The defendant, Mr. Edwards, was then detained and found to have an additional piece of crack cocaine in his pocket. And then the defendant, Mr. Edwards, spontaneously stated that he had only sold the cocaine to get a few dollars. He was then arrested and charged accordingly. The next case, that is 16 SC 142425, obstruction of a law enforcement officer. If this case were to go to trial, the state would prove these facts beyond a reasonable doubt: that on the 24th of March, 2016, at approximately 10:30 a.m. at 455 North Avenue, Atlanta, Georgia, in Fulton County, Georgia, Sergeant Barr and Officer Marr were patrolling that area. And while patrolling, they identified a wanted subject, Mr. Edwards, and they knew that he was wanted for failure to appear on sale of cocaine charges in Fulton County Court, Superior Court. The officers then advised Mr. Edwards to place his hands behind his back and stated that he had a warrant. Mr. Edwards then began to run away. He ran away and darted across the roadway into traffic. He jumped the fence at 647 Boulevard, a children's daycare facility, and the officer ran behind the building from another access point. Mr. Edwards was then tased in the side. He was tased by the officer's guns, taser guns. And then he was arrested and charged accordingly and transported to Grady Hospital. Your Honor, this is a case that isn't a fairly old case, but it's old because the initial resolution to the case was that Mr. Edwards would go into the Behavioral Health Treatment Court program, and he did not successfully complete that program. But I did speak with Mr. Tucker, and he stated that they are willing to work with him. And I just noted that on my previous conversations, even before today with Mr. Tucker, they stated that he was actually doing okay in the program. Just gotta ensure that he shows up. But I think this is a fair resolution. The state's recommendation is, and if he had previously the program, his cases would have been dismissed. But we are at a different point now, and so the state's recommendation today is 5 years to serve 1 year, and that 1 year is commuted to time served. And a special condition of probation to enter and to complete the Behavioral Health Treatment Court program.
Okay. Ms. Crawford, do you have any criminal history information for Mr. Edwards?
Oh, I don't know what happened. Yes, Judge, Mr. Edwards has nothing active with Fulton County, but he has an old 09 SC case. It was the first offender case out of Fulton County. Attempted burglary. Burglary, yes. And then he's on probation in Crisp County for false statements, violation of motor vehicle, and violation of motor vehicle license plate. But he has
felony
nothing.
probation?
Yes, in Crisp County.
Crisp County, okay. So he had a first offender that he successfully completed,
That's correct.
and then one other felony out of Crisp, and that's it as an adult.
That is correct.
Okay. Thank you.
You're welcome.
Ms. Patel.
Thank you, Your Honor. Mr. Edwards, if you don't mind. Stand at the podium.
Yeah, you guys have to take turns at the microphone.
Your Honor, before you is Mr. Edwards. He's 30 years old. He's the father of 4 kids. Prior to him being arrested on these charges, he was working part-time as a mover. He's currently unemployed though. He lost his job when he was incarcerated and has been struggling to find employment since then.
And why was Mr. Edwards arrested? Because of the Crisp County or this case? These
cases, there was a bench warrant out for him because once he was terminated from BHTC, I think maybe 6 or 8 months later, it came back and then was placed in judicial hold status for quite some time.
Got it. And how long was Mr. Edwards in custody as a result of the bench warrant?
46 days.
And that was when?
This was fairly recently. I want to say right around the start of COVID. I want to say March to April, perhaps.
Okay.
And so initially his cases were referred to drug court, and then drug court kicked it to BHTC because he had a diagnosis for bipolar and schizophrenia, and they felt that it would be better suited for him to stay in that program. As Ms. Sellers indicated, he was doing pretty good in the program. His issue at the time is that he has 4 kids now, but 2 of his kids were very young in 2016 when he was in the program and were not at an age where they could be in kindergarten or pre-K. And so he was mostly providing the childcare services while the mother of the child would go to work. And it was getting to the point where he would not show up to BHTC if he was taking care of his kids. And so Mr. Tucker explained that they would not be willing to take him back into the program until he could get his childcare sorted. So where we're at now is that unfortunately, but this somehow magically works, is even though the kids are at home because of COVID, his girlfriend lost her job. So she's at home and she's able to take care of the kids while Mr. Edwards is able to participate in the program. He does struggle with a drug addiction. It's actually that he's addicted to recreational pills, Percocet and Adderall for the most part is what he's using. Unlike many of my clients, he actually has quite a lot of family support in his corner. At his other court dates, not only was his mother there, but his brother and sister, they are actively involved. His mother and he calls me every week wanting an update on his case. And so we've talked extensively about how communication with BHTC is key. We understand that some things might come up in terms of childcare, but the program is very understanding as long as you let them know what is going on. And so I'm hopeful this time around he can complete the program. His mom seems to be fairly optimistic about that as well. The one thing that we'd ask is if Your Honor would consider waiving the fees while he's in the program. Right now, he doesn't have a job. We're hoping that that changes for him in the future, though.
I don't think you pay probation supervision fee while you're in the program because probation is not supervising you. But maybe Ms. Crawford can check. If she doesn't know directly, she could ask her colleague. But you're not going to have a probation officer. There's Officer Calhoun who oversees all of the accountability courts for probation, but I don't think so. But we'll get an answer to that. All right, I've got a bunch of questions for you, Mr. Edwards. Tell me, what's your connection to Crisp County?
John, I gotta get in touch with him. I've been trying to get in touch with him. I ain't been able to get in touch with him.
No, I mean, like, what were you doing in Crisp County? How did you pick up charges?
Oh,
Why were you in Crisp County?
no, I was with a family member. We was on our way to a family house. I have a family stay in Florida. She's a female.
Judge, I can't understand him. He needs to get to the microphone.
All right, you need to,
Oh,
there you go, okay.
I have a lady, a family member down there. She's a teacher down there in Florida. And me and some of my family members was on the way down there. And he hadn't got tired, and I had to end up driving for like 2 hours.
Okay, so you were with family, going to see someone in Florida, and got pulled over in Crisp County.
Yes, sir.
All right, that's all my question was about Crisp County. You have 4 kids?
Yes, sir.
How old is the youngest?
7 months.
So this can't have been the kid that was causing you to miss BHTC, because this kid would not have been alive.
No, it was my first 2 kids, my first 2 boys, my oldest kids, my
Okay.
5-year-old and my 4-year-old.
So you've got 5, 4,
2 and 7 months.
that's a pretty full household.
Yes.
Are you thinking about having a 5th?
No, not at the moment.
Not at the moment.
No,
What
sir.
about in 3 months?
No.
No, no, about another year.
No, I'm trying to get situated right now, get myself always situated for another
Good.
baby right now.
You've got a lot of kids. Are they all in the same household with you?
No, just 2 of them.
The youngest 2
Yes, sir.
are with you, and what's the last name of the young lady you stay with?
Horde.
Ford?
Horde. With an
Horde.
H, yes.
How do you spell that?
HORAD.
Okay, so Ms. Ford is the mother of your 2 younger kids.
Yes.
The 2 older kids are with their mother?
Yes.
Is she in Atlanta?
Yes.
Okay. How often do you see your older kids?
Well, I was seeing them a lot till I got on this ankle monitor, but I see them often though, like
You're
on
wearing an
weekends.
ankle monitor right now?
Yes.
Why are you wearing an ankle monitor?
It's
That's part of our bond?
Oh, yeah.
Okay, got it. So 4 kids, that's it for now.
Yes.
Ms. Ford is the mother of the 2 younger ones.
Yes.
What happens if you are, let's fast forward 3 months from now, you're in BHTC, it's going well, and Ms. Ford gets a job. You have, at that point, you have a 10-month-old, not old enough to take care of himself. The boy or girl?
A boy. You talking about the youngest?
Yes.
No, my youngest is a girl.
Okay, so she'll be 10 months old, can't leave her home alone. You're in BHTC, Ms. Ford gets a job, which is a good thing. You guys need the income. What are we doing? Are we having to quit BHTC?
Oh, no, see, I can call her sister or her mother or somebody. They're watching for me for a while.
Ms. Ford's sister?
Yes, or my sister.
Or your sister?
Yes.
You would have family members on either side who would watch the 10-month-old while you're at BHTC?
Yes, sir.
Okay, so you've been thinking through a plan.
Yes, sir.
You will be expected to get a job soon enough. Initially, the focus is BHTC, and it's not 8 hours a day, but it's daytime, so you might have a night job or something. But eventually, BHTC is just in the evenings, and you'll be expected to work. What kind of work would you do?
Probably trying to get back on the moving company job.
Okay. Have you reached out to them?
Oh, yes.
And why are you not back there?
Because the thing they had, they ain't even been working like that. You know, they working like big buildings like downtown and around Buckhead, like moving furniture and stuff like that.
And you don't want to do that?
Yes, I do, but he ain't been having space available right now.
Okay, he's got enough folks.
Yes.
Okay. Ms. Patel said you've been diagnosed as being bipolar and schizophrenic. Do you take medication for that right now?
Yes, sir. But I'm not taking it right now. I ain't even been to my doctor to get my prescription refilled.
How long have you been off the medication?
It's been a few months.
So that'll be a problem in VHTC. You'll need to be taking the medication that a doctor prescribes.
Yes.
Why will it be different then? Because you're not taking it now, why will you suddenly start taking?
I don't think, see, I ain't been taking, I don't really think I need to take it.
Okay, is this a disagreement you have with your doctor? Your doctor says you should and you say, no, I'm not going to?
No, not saying I'm disagreeing, I just ain't been to talk to him about it.
Okay, so you'll keep having a conversation with the medical professionals about you really need to take it, or maybe a lower dose, or maybe none at all.
Yes.
But if the doctor says, you know what, Mr. Edwards, I need you to believe you should take this medication, is that something you intend to do?
Yes, then I continue to take it.
Okay. When are you next going to the doctor?
I got set up for an appointment.
You do. The HTC will not want to do a whole lot with you if you're saying, I'm not going to go see the doctor.
Yes, I'm going to see him.
Where do you go to see the doctor?
Over there on Boulevard, like by Atlanta Medical.
Ms. Patel said that the drug or drugs you struggle with the most are recreational pills. I think that's how she described it. So it's not your prescription.
No.
But it's prescription drugs. It's not cocaine or heroin or
No.
meth. It's pills.
Yes.
Okay. And is that something that you struggle with now, or 2 years ago you did?
Oh, now years ago I did, but not now though.
Okay, so then why do you think VHTC is going to help you out? You will be around folks who are actively addicted to drugs, whether it's marijuana or cocaine or pills.
No, I can stay away from it.
I didn't ask the question well. I hope you can stay away from it.
Yeah.
But the point of going into VHTC is to get help with an addiction.
Yes.
And you're telling me, I solved that one, man. I don't. And why do you need VHTC? If you can just flip the switch and say, I don't
No,
know.
I know BHTC is like, it's just, I think it's something I just need. Because going in a building, it's just, it's just a lot of help there.
Okay.
And things I can see.
All right. Ms. Stellers, in the 16 SC case, there's a criminal trespass count that alleges some damage was done to some private citizen. It's less than $500, so it's a misdemeanor. I didn't hear you say anything about restitution. Is this case of such an age that there's really not going to be restitution?
No, Your Honor.
Okay. Ms. Crawford, were you able to learn whether one pays probation supervision fees while in drug court?
Judge, I tried to reach out to Mr. Calhoun. I was not able to get him, so I have an answer for you later.
Okay, thanks. All right, Mr. Edwards, I asked you a bunch of questions. Do you have any questions for me?
No, sir.
Anything that we've talked about that you do not understand?
No, sir.
Okay. Well, Mr. Edwards, I find there's a factual basis for your plea in both cases. One that I'll call let me ask one more question. So the more recent case, still old, but the one from 2016, when you ran from the officers, you got tased. Were you wanted for this other case? What did you think they wanted you for?
See, really, I didn't know, because the officers that arrested me, I used to stay on Boulevard with my child's mother, my first kid. And the officers always bothered me. So I feel like they was trying to bother me or something.
Okay, and you didn't want to be bothered?
Yes.
Got it.
Because I was on my way to class that morning.
Okay. Well, I don't think there are any warrants out for you now, so hopefully.
That's a good thing.
That is a good thing. Hopefully officers will leave you alone. Okay. Well, I do find there's a factual basis in both your cases, the running from the officer's case as well as the cocaine case. So cocaine you've sold before, but it's not a drug you use a lot?
Mm-mm.
No? I also find that your pleas are knowing and voluntary. Voluntary means that you're entering this plea of your own free will. It's forcing you to do it, but after you thought about it, talked with your lawyer, maybe talked with your mom or Ms. Ward, you think that the right way forward for you is to enter these pleas. Is that correct?
Yes, sir.
And then a knowing plea is simply one where you've understood what we talked about and get what's going on. Is that the case?
Yes, sir.
Then I'm going to accept the pleas. In both cases, I'm sentencing you pursuant to the Probation Options Management Act. And all that means, Mr. Edwards, is that when you are eventually on probation, because the last part of your sentence, you'll be just on probation, actually on probation the whole time. But while you're in VHTC, you don't report to a probation officer. You are supervised by the VHTC personnel.
Yes, sir.
They're sort of like probation, but they're doing a whole lot more. But eventually, when you graduate from VHTC, you may be on additional probation, because it's 4 years in this case. If there's a problem while you're on probation, and it's a small problem, maybe you miss a meeting or you're behind on paying something, that kind of level of thing, you and probation will work that out.
Yes, sir.
If you get arrested on new charges, that comes back to me.
Yes, sir.
All right. So in the 14 SC 124921 case, I am going to sentence you on count 1, and you're charged on counts 1 and 2 in that case. I think that's right. Old indictment, I have to, one page at a time. I think you have a code of Ms. Henry, person who's old. So you're charged 2 counts, and for both counts, I'm sentencing you to 5 years to serve 1 year. That 1 year is reduced to the time you've already served, and the balance is on probation. So it's effectively 4 years probation. I'm running those counts concurrently at the same time. A special condition of your probation is that you will enter into and complete the VHTC program. So if you get terminated because you can't make it because you have too many kids, or because you decide it's not interesting, get arrested for something else and they kick you out, anything like that is a violation of your probation. That kind of thing comes back to me or the VHTC judge, who is going to be Judge Richardson. And you start, you'll be working with a woman named Judge Richardson. And one of the 2 of us would deal with you getting terminated. But let's hope that doesn't happen.
Yes, sir.
Get through VHTC. In the other case, 16 SC 142425, I am sentencing you on count 1 to 5 years to serve 1. And that 1 year will be reduced to time served. The balance will be probated. And the other 2 counts are misdemeanors, and I'm going to make those 12 months to serve. Those will be reduced to time served, and they'll run concurrently with count 1. So again, basically 4 years probation. Special condition of the 16 SC case, same thing. Enter into and complete VHTC. And I'm running the sentences in both cases together, concurrently. So I said consecutive, I meant concurrent with the 2 misdemeanor counts. Overall, you have 4 years probation.
Yes, sir.
And the state, I believe, Ms. Sellers, you have moved to null pros the other 14 SC case.
Yes, Your Honor.
All right, I'll take care of putting the stamp on the document, all that stuff.
Okay. Thank you, Judge.
I think the last thing we need to do, there's an indictment and an accusation, the 2 things you pled to. Normally, Ms. Patel would hand them to you and you'd sign indicating that you're entering guilty.
Yes.
Not normal times, they're on my screen. They're actually sitting on a printer back in my office because we can't get this printer to work yet. Do you authorize me to sign both those cases, the indictment and the accusation, on your behalf?
Yes, sir.
All right, Ms. Patel, may I sign on your behalf?
Yes, Your Honor.
And Ms. Sellers, do you authorize me to sign your name on the accusation and the indictment?
Yes, Your Honor.
Okay. I think that's everything. I will add the language, Ms. Patel, about waiving the reporting fees if in fact there are supervision fees. I don't think there are, but if there are, we'll waive them. Mr. Edwards is going to have to deal with fees within the HTC anyway, once he starts working.
And Your Honor, if you could just ask Ms. Sellers if she's okay with Your Honor signing the referrals on her behalf?
Those are the referrals to BHTC, but this is probationary referral. So I would certainly, if she says yes, her signature is not mandatory on those. It's not a diversionary.
Correct.
Got it. Okay, I'm still learning that form. Ms. Sellers, one more thing that's going to be signed today. Ms. Patel and Mr. Edwards have already signed it, but it's the BHTC referral form. Are you okay if I sign that for you?
Yes, Your Honor.
All right. Ms. Sellers, do you have anything else in Mr. Edwards's case?
Nothing further from the state.
Okay. Ms. Nelson, any questions about what we talked about?
Yes, on the fees, do you want it on the indictment or I mean, on the sentence or not?
What was the question?
Do you want it waived, his fees waived on the sentencing form?
No, thank you, please. I'll amend it if there are in fact, oh, Ms. Crawford has turned blind. Maybe she has an answer.
Yes, Judge, I do have an answer. They are ordered to pay fees if they're going to be HTC. So if you would like to waive them, you can put that in the order.
They're ordered to pay the probation supervision fees?
Yes.
Okay. So correction, please indicate on the two sentences, Ms. Nelson, that Mr. Edwards' probation supervision fees are waived as long as he is in BHTC.
Okay.
Thank you. That makes sense. Do with that. Ms. Patel, anything else from Mr. Edwards?
No, Your Honor.
All right, Mr. Edwards, good luck. Take care of all those kids. Be grateful for the family you have that's helping you get through this.
Yes, sir.
Do your best to make good choices.
Thank you.
All right.
All right.
Judge, may I approach the paperwork?
You bet. Thank you.
All right. Well, Judge, may I be excused?
Yes, ma'am. Thank you. I'll see you tomorrow for drug court stuff.
Yes, bright and early.
All right.
See you then. Bye-bye.
Mr. Franklin, do you have anything else?
No, I was hanging around for Mr. Tail. I'm checking my email. I think I made a response back from the person who was supposed to do the evaluation.
Okay, I'm gonna let folks on the call go. Thank you, Mr. Forte. I don't know that we need coverage for drug court. I don't think that anyone's being terminated. And I don't think we are doing the calendar after. I assume you're off tomorrow, at least with me. Is that your understanding?
Yes, sir.
Great, okay. Well, take care of the household and we'll see you, maybe not till next week. Okay.
Yes, I think the next calendar I have is the 29th.
All right, well, enjoy the downtime.
Thank you.
All right, thanks, Ms. Nelson, Ms.
You're
Crawford.
welcome. All right.
Thank you.
So evidently you were correct. The case manager was on the call. Reached out, spoke to my client, spoke to my wife's sister, left a message, provided her with the address, advised to speak to the tech staff in person for a telehealth appointment for Mr. McGuire. If she had any concerns, then I set up the assessment, reach back out, to assist, and gave the 10 Park Place address.
Oh, 10, not 55, 10 Park Place.
Yeah,
Right.
$55.
Okay. But no, that's not where he shows up.
Yeah, but he said he spoke with the sister, but also said he left a message. I'm not sure.
Okay.
I'll follow up with the sister and make sure that do what I can to make sure that she
Okay.
appointment.
All right, good. All right, thanks, folks. In theory, on Tuesday, we will have our in-person calendar, where it's inmate in person. We are on the cycle for every Tuesday. It was originally going to be 7, but we got together with county management and the sheriff's office, and they asked to reduce that because case counts are up and whatnot. So Monday is the start, but we're not Mondays, we're Tuesdays. And if we have 4 inmates where it makes sense to bring them over within the course of the day, we ought to be able to deal with all 4. But if we don't have 4 because it's every Tuesday, maybe some Tuesdays we don't have 4. But it can be anything where you think it's better to have them here in person. Motions hearings is sort of the ideal. We'll see. All right.
They have another question for you. I know you always said that we had suggestions about things and all of those too. The last week or 2. I know
So this
that-
is a suggestion, not a question.
This is going to be a question at the end.
Okay.
I'll raise my voice at the end.
Yeah.
Amongst other talks, the last couple of weeks, we've had a lot of court. And I think we're kind of at the point where I think we were at this point before we had worked down as much as we could. We needed some time to kind of focus more so just on contacting people or identifying what we're discovering. I'm not sure what court is. I know we have the stuff for the 28th or 29th, maybe August 6th already. But I think we're at a point in time where we need kind of some moment to gather ourselves again. I imagine we have one more push of cases other than the ones that have to be tried. If it's a time that we could have that considered, so that we can work on some stuff.
Sure.
I know Cassie been doing with it a lot. Officers are, for various reasons, not cooperative with it.
Right. Well, and she's got to deal with all of them. You guys at least get to split it, so I'm sure it's falling on her pretty hard. No, that's a fair request, and I'll get with, hey, do you need Ms. Patel? Yeah. Okay. I'll get with Ms. Nelson. I know she's anxious to just make sure cases are getting touched. She's always afraid a case is going to get forgotten about, not so much by the lawyers, but she's been at this much longer than I have, and she just wants to guard against lawyers who will do the minimal amount as driven by accountants. I'm not suggesting that's anyone assigned to this division, but that's where she's coming from, which is helpful to me. But we do need to strike the right balance. So I'll look at the calendar over the next few weeks. I know, for example, for the rest of this week, you have nothing in court, so you have lots of work to do. But if we use this week as an example, we were only on calendars for a day and a half. The rest of the week is open. But the week before, there was a whole lot of purple. I had criminals purple next week, so there was a lot of purple. Yeah. We are having less civil because folks are working things out. And that means Ms. Nelson finds more spots where she can put things. We also have these new opportunities to have evidentiary hearings, and I think it's going to be every Tuesday.
Yeah, I think the stuff every 2 days is fine.
Yeah.
Just like everything. Just kind of like I said, the last week, 2 weeks, it's a lot of purple. Yeah. Just
a little less purple.
A little less purple, just so we can regain and regroup. When we had that moment, we was like, well, we're trying to resolve stuff. But we had a chance to kind of work it up, and then a lot of stuff.
Yeah, there were results.
Yeah, got results. I think we're kind of in that point now. Yep. I think the calendar reflecting that we're probably going to have some less court time. So we'll probably be able to do it anyway. Yeah. But I want to make sure we brought it up. We're in a position where the level of advocacy we need to have in terms of pushing back on the state in terms of some certain deadlines. Honestly, I can't really hold them accountable for certain things because the world is not allowed to operate. Right. Because, I respect Cassie, respect Warren, thank you for telling us, Snyder. Yeah. We don't want to lessen our duties to our clients, but we should say, hey, the deadline was today. Yep.
No, that's right. And you're being realistic, because if you came in here hooting and hollering about, I didn't get the 911 call by this date, the answer is because College Park, the one person who handles that is sick. The answer is you didn't get it on time. And it's not like we're going to have a trial anyway. But we do need to have stuff move along. Someday we'll have trials again, and it will be really frustrating if the answer is you're not ready because you had to ask 100 times for something and you never got it. Yeah. So it's a point well taken, and a lot of this stuff is a little pendular and that there's not enough and then there's too much, and we'll try to get the right balance. I think the weekly inmates coming here calendar will create a new rhythm. The only two regular calendars that we have that I want you guys to stay focused on is every week we can have up to 4 people, and then it's about every other week, there are 15 of us, so it's not quite every other week, but it's, I guess it is like every 8.5 days, we have one of our jail Zoom calendars. So those are opportunities to deal with inmates. The folks on bond, I'm happy to be more flexible with, but when we're dealing with the folks in custody, I don't want to miss our windows because they happen less frequently.
Yeah.
And that's where I assume everyone is feeling the most pressure. In for 6 months, I want to be here, but you're not going to get a bomb, we can figure out what we can do. So we'll try to keep those windows open and have fewer distractions.
We appreciate it. Thank you.
You bet.
Thank you, Judge.
Take care.
Yeah.
Thank you so much. Appreciate your help.